added together, they really provide what sometimes referred to as the rape shield provisions. And people believe that they're being applied unfairly, with the result that people are being deprived of fair trials in sex cases. And there's been 100, 200 cases where they've always been applied in relation to it. But things took a really, really sinister turn around about 2002, and there had been a lot of campaigning around the issue that not enough people were being convicted of rape. I put it as boldly as that because it's always discussed in percentage terms, and I always say, well, who is it? Who was it that was acquitted last year who you think should have been convicted, or is it just enough that 25% of men get convicted, even the innocent ones? What do you want? And then the next substantial change was about 10 years ago, in 2013, and that was really the final nail in the coffin for fair trial.
The defendant had text messages, wanting to meet this person, photographic proof of the person, I think the day at the beach in a bikini swimwear, cuddling, stuff like that. But the prosecution were saying that these people had no contact for a long time, and this incident just happened. There was nothing else happened before then, and that was deprived from being used as evidence.
Defence lawyers are being prohibited from asking questions that 99 people out of 100, if you went to the Buchanan Galleries on a Saturday afternoon, could not understand why that was been disqualified, why you weren't allowed to ask that question. They're performing mental gymnastics to find ways to avoid questions being asked, which most non-lawyers would think absolutely essential for a fair trial.
And I think the law, when it was brought in, was probably brought in for wholesome intent and a good reason, but it's the application that's the problem.
Before anybody gets any sentence for anything, there's got to be a fair trial process, and I'm sorry, but in relation to this issue at the moment, there isn't. And the minute the senior judges are making these kinds of decisions, it makes it very difficult for all the judges, even the new judges. They've really got to kind of fall into line, because if they don't, the Crown appeal the decision, and all this is straightened out before the case even gets to trial. There's a very powerful advocacy group supporting rape victims, and I don't have any problem with that. I agree that they should be supported, but they're very, very powerful. And the SNP government has repeatedly said that they're putting victims at the centre of the justice system. That's a line that they often use, how not enough people have been convicted and all that. And then they'll come to me and it's, well, surely you're not justifying this, you're justifying guilty men getting acquitted, and I'm not. I don't want guilty men getting acquitted. And, I don't want any of the jobs. I don't want any of the jobs that the SNP give it. I'm not interested. I'll stand on my own 2 feet. But they've created an awful lot of government jobs. They've created an awful lot of sheriff's jobs at 180 grand a year, and you're not getting a sheriff's job at 180 grand a year if you do what I do and come up onto the telly and say, well, this stinks to high heaven.
Hi there folks, welcome to a special edition of my 10-minute moan, and it may go on a wee bit longer than 10 minutes, and I've got a guest here, a very special guest who is one of the top in his trade, AC. Yesterday I was at a protest in Edinburgh where there was a group of people, the GIMS is what they're called, it's Justice for Innocent Men in Scotland, and they've started a campaign to try and get fair trials for people accused particularly of sexual crimes, etc. And I didn't know too much about it. I went up there just to interview people and learn more about the topic, and a very interesting topic to me. I was really impressed by the people that I spoke to. I learned a lot about their campaign and why it's important, and it's something that I still want to learn more about it, and hence the reason I'm really grateful that Thomas Ross has come on to speak to us about it and give us a sort of legal background to what is going on and why it's there. So without further ado, Thomas, how are you? And thank you very much for coming on.
Hi, Craig. No, pleasure as usual.
So your name actually came up yesterday off camera when I was talking to some of the ladies there, and I said to them, he's got anybody in the legal profession that's advising you and talking out for you and things, and they mentioned that you'd done a talk previously about this specific issue in the law. Now, forgive me for my inexperience here, but there's two acts or two laws that they're trying to repeal. Is it 724 or 274 and 275, something like that, which doesn't mean anything as a layman, but could you maybe tell us what it is and why it's important, and about the talk that you've done previously that they were describing to me?
I did meet them. They talk about section 274 and 275, but basically they added together, they really provide what sometimes referred to as the rape shield provisions. And people believe that they're being applied unfairly, with the result that people are being deprived of fair trials in sex cases. And really it's not easy to explain it because it's an incredibly complicated provision, and there's been 100, 200 cases where the law has been applied in relation to it. So it's not very easy to state it simply. But back in 1983, the Scottish Law Commission responded to concerns essentially that rape trials were being used to humiliate rape victims. And essentially, rape victims were being asked about things which had nothing to do with the allegations which were being made. And the main areas that the Law Commission considered back in 1983 was the fact that rape complainers were being asked questions to show they were bad character, or that they were associating with prostitutes, that rape complainers were being asked about intercourse with men other than the accused before or after the rape, and sometimes even when asked about intercourse with the accused on occasions other than the alleged rape. The laws in Scotland was a bit flexible back then. There wasn't any written bar to these things, with the result that some judges seemed to allow it and other judges didn't allow it, and they believed that it was necessary to clarify it. So back in 1985, for the first time, the law was written, and nobody had any real problem with the law as it was written back in 1985, because I think most fair people could see that it was mildly scandalous that women were being asked about other boyfriends and other partners, which really had nothing to do with the case, to embarrass them and really to drag their character through the muck. So the law as it stood then operated pretty satisfactorily, at least as far as we thought. And if you wanted to, if there was a special reason why you should be allowed to ask a question of character, for example, if the witness came in, if the complainer came in and said, I'm 40 and I've never been in trouble in my entire life, so the jury should believe me because I'm an honest person and I've never told a lie in my life, and you know that she's got 3 pages of previous convictions for theft, you could make an application to the judge and say, well, look, she's kind of brought this on herself. She's made out to the jury that she's an honest person when we all know that she's not, and therefore it's only fair, if there's to be a fair trial, that the jury get to hear that so that the judge could allow it. But things took a really, really sinister turn around about 2002, and there had been a lot of campaigning around the issue that not enough people were being convicted of rape. I put it as boldly as that because it's always discussed in percentage terms, and I always say, well, who is it? Who was it that was acquitted last year who you think should have been convicted, or is it just enough that 25% of men get convicted, even the innocent ones? What do you want? And in response to the concern that not enough people were being convicted of rape, a much harder line has been taken progressively. 2002, they rewrote the law completely, and they included what's referred to as behaviour. So you weren't allowed to ask about behaviour which might show that the witness was been dishonest, and I'm putting it very generally to try and avoid the very technical language that's used. And that was the start of the problem, because behaviour can cover anything. Anybody can see asking a rape victim about sex with other men is clearly completely out of order. But what's behaviour? You know, did you send somebody a Valentine's card a year after you said that he raped you? Most people might think that was relevant, but for the first time, the judges could say, well, that is behaviour, and we don't think that you should be allowed to ask her about that, you know. And year on year, it's got worse. And then the next substantial change was about 10 years ago, about 2013. And that was really the final nail in the coffin for fair trials in a way, because they could see there was a problem with the Act. The problem seemed to be that judges were still finding ways to allow defence counsel to ask questions. And then a new leg developed where the judges were saying, well, we don't even need to get to 274 and 275 because what you want to ask this witness is plainly irrelevant. So I'm just deciding that it's irrelevant and we don't need to consider it. So the combination of all of those things has led to a situation where defence lawyers are being prohibited from asking questions that 99 people out of 100, if you went to the Buchanan Galleries on a Saturday afternoon, could not understand why that was been disqualified, why you weren't allowed to ask that question. You know, they're performing mental gymnastics to find ways to avoid questions being asked, which most non-lawyers would think absolutely essential for a fair trial.
Yeah, there was a lot of talk. I mean, there was 3 ladies kind enough to give me their time yesterday, but I spoke to a lot more, and I spoke to those ladies off camera as well. And it's kind of. I think I was on the right track yesterday because I can't remember if it was on camera or off camera. And I said, look, I'm trying to understand this. And I think the law, when it was brought in, was probably brought in for wholesome intent and a good reason. But it's the application that's the problem. Now, you as a very experienced KC, you're sort of saying the same as me, that it's a journey that this was taken in reality. So, I mean, one of the cases, one of the things that were explained to me, I thought it was quite outrageous, where the defendant had text messages, you know, wanting to meet this person, photographic proof of the person. I think it was a day at the beach and the bikini swimwear, cuddling, stuff like that. But the prosecution were saying that these people had no contact for a long time, and this incident just happened. There was nothing else happened before then, and that was deprived from being used as evidence. And during the day, nobody. I think one person was talking about being innocent, and the whole thing wasn't about being innocent or guilty. The whole topic tends to be around getting a fair trial. And I think I said to one of them, look, I think it was as a nephew, and I said, if he'd went to trial and was able to present in his eyes a fair defence and was still found guilty by his peers, then that's kind of, you know, that's just, you know, what we accept in a court. But when you don't have that, even the possibility of offering what you feel is a fair defence, then it's no wonder these people are upset, they're angry. And so it sounds like you're kind of agreeing with them, Thomas. And when they spoke, and you've spoken about the talk he gave, where was that, and what was it all about? When you spoke about this?
You were talking, before I get to that, Craig, you were talking about text messages. Can I give you 2 real life examples of things which were disqualified? Yeah. Right. So these are 2 real life examples from a case which was reported. Text message sent by the complainer to the accused. Ha ha ha, we had far too much sex. You're a horny devil. Disqualified. Jury never got to hear it. Accused sends a text to the complainer. Do you even like me? Yeah, I do. From first impressions, you were a bit full on with the kissing and sex. But if I didn't want it, I would just have left. Disqualified. Jury never got to hear that. In fact, that one, they complained that the lawyer hadn't asked the court to put that forward, but the appeal court refused the appeal on the basis that if the lawyer had made the application to be allowed to ask about that text message, that the prospects of a successful application would have been low. So it was never asked, and a conviction stood. So the reason I did the talk, which was your question, it says to me, I only do trials. I don't really do many appeals I never prosecute ND. I don't do anything other than criminal work in the High Court, and about 75% of the cases in the High Court are criminal sex cases. So every day there's 8 courts, about 5 or 6 of them will be doing sex cases every day. In 2022, I made it public I wasn't doing any more sex cases, so I voluntarily removed myself some 75% of the available work in the High Court. And part of it was depressing me. But one of the reasons it was depressing me was I was concerned that men were not getting fair trials because this type of material that I've just read to you was routinely been disqualified by the judges. And so I'm sitting with a 21-year-old guy. He's got his mum on one side and his dad on the other side. And they would tell me about material like this. They would say, well, surely the jury can't convict him when they hear about this. And I'll say, they're not going to hear about it because the judge is not going to let me raise it. And they immediately lose confidence in you because they're thinking, this lawyer's a fucking idiot, you know. If he can't get this put forward, it must be his fault. No, it was never my fault, you know. It was the way the law was being applied. But yeah, it makes the job really, really difficult when people don't have confidence in you because you're the one that has to tell them, listen, wee man, there's no way we're going to be allowed to lead this. And, you know, one of the cases, every time I hear one of these cases, I think this is the worst I've heard. And then a week later, I hear an even worse one. But let me give you another example, Craig. This is a case that went to the United Kingdom Supreme Court, and it's still to be decided. But from what I've heard from some people who were involved in it, we're not very optimistic that the Supreme Court are going to help. But the circumstances of the case, the Keir case, and this is in the public domain, the accused and the complainer were workmates. They were in a bar on a works night out. They were becoming a bit amorous in the bar, and the complainer was seen on CCTV to sort of beckon the accused into a disabled toilet in the pub. They had sex in the toilet, and they then came out and they got a taxi and went back to his house. I think his wife was away for the weekend or something, went back to his house, and they had sex in the house. And the two of them woke up in the morning and she complained. And part of her complaint was, well, look, he was my boss or he was my supervisor or something. We didn't have that kind of relationship. I would never, ever have consented to having sex with him. Now, she didn't know that the CCTV in the pub was there and it had captured what they had been up to in the pub. So she was making this allegation. And of course, when the guy was interviewed by the police, he was thinking, well, this is terrible, but the one comfort I've got is the CCTV for the pub will show exactly what happened in the pub. So the Crown charged him with a rape in the pub, unbelievably, and a rape in his house.
Wow.
And so they made an application to use the CCTV from the pub. The judge was kind of sympathetic about the CCTV in the pub. And when I tell you what happened next, you're not going to believe it. What happened next was that the Crown withdrew the charge on the spot. They withdrew the charge in relation to the pub.
Yeah.
So it just went with the house. So he then says, the judge then says, well, what has what happened in the pub got to do with what happened in the house?
Oh my God.
So he was not allowed to lead any evidence about anything that happened in the pub. And all the jury heard was that she woke up in the morning in bed with him and couldn't remember anything and said to the police, well, I don't really remember it, but I would never, ever have had sex with that man because of the nature of a relationship. He's in the jail. That guy's in the jail serving a sentence. And, you know, let me tell you, you think from that story it can't get any worse. He got interviewed by the police, and as you know, that anybody who's interviewed by the police has got the right of silence, so you don't need to answer any questions. Yeah. But he did. He did answer the questions, and they asked it. So just concentrate on the words here because the words are important. So he got interviewed by the police, and the police asked, what happens when you got to the house? And his answer was, we went back and we continued to have sex that we'd had previously. So we went back and we continued to have sex that would obviously previously, I think that was the words. So the court said the jury couldn't hear that. So the court edited the sentence to, we have sex. We have sex. Doesn't even make any grammatical sense.
No.
So they can't put in words that were never said. They can only use the words which are in the sentence.
Yeah.
But the only way they could edit it in a way that didn't allow the jury to hear anything about what had happened previously was to edit it to, we have sex. So it's not just that people have been deprived from asking questions or leading evidence from witnesses. It's not just that. In relation to, for example, interviews which happened 2 years before the trial, they've been edited as well so that the jury don't get to hear what the guy's defence is.
Yeah. See, Thomas, I've said for a while that this type of crime must be the most horrific crime that you survive. Because I think the only more horrific crime is murder, and you don't survive that. And it is a very serious, horrific, horrible thing that blights society. So when you talk about these topics, it's very easy for folk to, not want to listen, not want to get involved in the debate. But the reason that it's got my eyebrow up is I'm a great believer in democracy and justice and fairness and all these things. And unfortunately, if you believe the same, then you have to allow everybody to have a fair trial. But this isn't. It sounds as if it's not just they're not getting a fair trial. This is actually verging on stitching people up.
Well, they're not getting. Some people are not getting a fair trial. I mean, I've not had any personal dealings with a case since it took me about a year to get through them all. So I think the last trial I did was about 2023 or something. But I can tell you this, obviously we've got common rooms in the High Court, and when you hear somebody, another advocate, upset about something that's happened in court, 8 times out of 10 it's this, that I asked the judge if I could ask
Seriously,
this.
it's that big an issue?
Oh, massive issue. Massive.
Wow.
Massive issue.
And the majority...
It's very, very...
Did you say 75% of the cases in the High Court are sex cases?
That's an estimate that people... I've never done the sums, but routinely people use that as an estimate, and that's my experience. There's 8 trial courts in Glasgow, and routinely more of them are being used every day for sex cases. The judges say it. I speak to the judges, and they say one of the judges did 7 rape trials in a row.
Wow.
In a row. And I mean, they're hard cases. There are a lot of... I'm prepared to accept that most allegations which are made are true allegations, and you say it's a horrific crime. That's another reason that I gave up doing them. It wasn't just this. I mean, this was a big, big part of it. But, there's some monsters out there who are doing terrible things to women. And, I don't know how long I've got in the job, maybe 10, 15 years. I don't want to be hanging about with monsters, So there's a whole number of reasons. I'm not pro, anti-women or anything like that. Quite the opposite. I think that the sentences for rape should be bigger than they are, actually. So, but I also think before anybody gets any sentence for anything, there's got to be a fair trial process. And I'm sorry, but, in relation to this issue, at the moment, there isn't. And, the minute the senior judges are, making these kinds of decisions, it makes it very difficult for all the judges, even the new judges. They've really got to kind of fall into line, because if they don't, the Crown appeal the decision and all this is straightened out before the case even gets to trial, You've got to make the application at the preliminary hearing stage. So it's not like you just stand up in the middle of the trial and argue. You've got to do it before the trial. And one of the purposes of that, I suppose, is if the judge was to go rogue and say, oh, no, I think it's only fair that the guy should be allowed to ask this, Crown can appeal it, and the appeal court can disqualify it before you even get to the trial.
Yeah, I'm going to ask you a question here, Thomas, which is quite a tough one, and I totally respect, if you decide not to answer this. I totally get it. But do you feel, or do you think there's a possibility that this has been driven politically or otherwise? This isn't just something that's happened organically.
Yeah, well, it coincides with, there's a very powerful advocacy group supporting rape victims, and I don't have any problem with that.
Mhm.
I agree that they should be supported, but they're very, very powerful. And the SNP government has repeatedly said that they're putting victims at the centre of the justice system. You know, that's a line that they often use. And, you know, it was quite noticeable, they introduced a victims and witnesses bill, and it was obvious to see who was at the launch. You know, the people who advocate for more convictions for sexual offences are
Mhm.
very, very close to those who make the laws. You know, now
Right.
that doesn't necessarily mean that there should have been any impact on the way the judges operate, because the judges are
Mhm.
independent. And but maybe coincidental. Nobody thinks it's coincidental. They did a review. You know, Lady Doreen did a review into the way in which sexual cases were conducted, and expressed the view that she had spoken to some judges who were surprised at some acquittals in rape cases. You know, and that obviously, when an experienced judge says that in an official report, it only adds fuel to it, because, you know, rape crisis and other advocacy groups jump on that and say, well, look, even the judges are seeing it, that you know,
Mhm.
guilty men are being acquitted and all that. So it's
Mhm.
part of I'm not criticising Andy. You know, I mean, they're entitled to go and advocate for their own cause. The
Mhm.
problem, Craig, is, and I've been set up for this, I've been on Scotland Tonight, and I've been on the BBC programme late at night, you know, and you're always presented as, well, here's the pro-rape guy, you know, here's the,
Yeah. Yeah.
why are you defending, you know, why are you sticking up for rapists? And you know,
Mhm.
so, you know, routinely I'll go on with Sandy Brinley. I've been on half a dozen times with Sandy, you know, and Sandy gets 15 minutes to rattle on about how not enough people have been convicted and all that, and then they'll come to me and it's, well, surely you're not justifying this, you know, you're justifying
Mhm.
guilty men getting acquitted, you know, and I'm not.
Mhm.
I'm not. I don't want
No.
guilty men
No.
getting acquitted. You know, what I'm saying is,
Mhm.
there's a trial process, and you've got to preserve the fairness of the trial process. But I tell you, there's not many people backing me up. You know, it's really, really difficult, because it's a very conservative, with a small c, profession. And, you
Mhm.
know, I don't want any of the jobs. I don't want any of the jobs that the SNP give it. I'm not interested. You know,
Mhm.
I'll stand on my own
Mhm.
2 feet. But
Mhm.
they've created an awful lot of government jobs. They've created an awful lot of sheriff's jobs at 180 grand a year, you know. And you're not getting a sheriff's job at 180 grand a year if you do what I do and go into the telly and say, well, this stinks to high
Mhm.
heaven, and it's time we did something about it. So
Mhm.
most people, you know, you're given the jobs, it buys a lot of silence, Craig, you know. So the result is very, very, the lawyers, and I'm not criticising them, I understand they've all got families and mortgages. I
Mhm.
understand it's attractive to them to take government jobs. You know, I've got that big pension at the end of it and all that. I've got it. But, you know, I can tell you this, that's all that people complain about most of the time in the common rooms. And, you know, who's speaking about it in public? Those
Yeah.
brave women who were outside the
Mhm.
court in Edinburgh
Mhm.
yesterday were speaking about it. They've got a direct personal interest, but there isn't
Yeah.
many lawyers speaking about it.
No, no, and hat off to you for doing so, Thomas. But yeah, and I got that yesterday as well. The feeling that I went there, no really knowing what I was going up to witness. I just, I was keen to learn from these people, and what is it? What is your problem? And what is it you want to happen about it? And I said it to a few of them, because of the topic. Society's very scared to touch this topic,
Mm-hmm.
but that doesn't mean it shouldn't be spoken about. And my sort of spin on it is, it's not about getting guilty people off with things. It's about preserving the notion of having a fair trial. And
Mm-hmm.
if you don't protect these things, then what do you do when it's your turn? When it's you, it's the flip side of this. And one of the girls that spoke, I think she was Polish. Yeah, she was, Marsha,
Yeah.
who was kind enough to give me an interview. She actually opened right up when we were doing her introduction, and her part that we recorded was like, "You're not safe. people, males in Scotland are not safe. Nobody is. And I kind of think, if what's happening then is people don't want to talk about it because it's not them. But if it was them, they'd want everybody to talk about it. And I totally understand it. It's a horrific crime, and nobody. It's important to hear you as a defence lawyer saying, look, if people are guilty of a crime, they deserve to be punished for it. And you're saying you believe the punishment should be even higher for it.
I do.
Yeah, you're categorised in some quarters as being you're that pro-rape guy. It's no. It's about fairness. And if we accept unfairness in some parts of the judiciary, then you can't really complain when it's about half time or something that hits you.
I'm thinking I've maybe been a bit unfair. I'm not saying that all the lawyers are silent because they're chasing a government. I'm not saying. I might have sounded like I'm saying that. That's not fair. That's not right. A lot of them are generally pretty conservative and quiet, and don't want to fall out with the judges because they like the judges. Most of the judges are decent people and they don't want to be seen to be public criticising them. I understand that as well. But the other problem, Craig, and you know this better than anybody, is they see the stick I get on social media when I put my head above the parapet with something and I get terrible abuse. And then I go to work on the Monday and people say, why do you do this? Why don't you just keep your fucking mouth shut? And you wouldn't get all this backlash from, people on social media and all that. So that is part of it. A lot of the lawyers are brighter than me and, I've got very intelligent, important things to say, choose not to say it because they're worried they're going to get the backlash. I mean, I'll talk to anybody about it. Whereas people are worried about, we're worried about all sorts of things. Maybe I'm just at the age where I'm not really as worried as I might have been. I mean, I wasn't doing this when I was 35 and I had a big mortgage and a couple of kids and all that, so I'm in a kind of privileged position now where I'm not really too worried about, where my next mortgage payment's coming from. So there's that as well. I don't, maybe it was a bit harsh on some of the people. I'm not saying that they're all.
No, I think you're generalising a fair. Yeah, I think you're generalising a fair point. It's no, you're not suggesting folk are corrupt and stuff like that. You're just suggesting that some people might be maybe just no scared. But their responsibilities are different, and they maybe can't do the things like you and I do. Or two characters that if something's right and wrong, that kind of is the most important factor. Personal, what people think about is people secondary. And that's very much why I do what I'm doing. It's like if I see something that's wrong and I believe it to be wrong, then I'll speak out about it. And you and I spoke last week about some of the consequences that can come my way, and we're not going into that just now. But so I'd asked you, and you were starting to tell me, and then I sort of drifted off a wee bit. So I do apologise. Get back to the talk that you gave. Was that in a professional setting where you spoke about this? And what was it? And what were you saying?
It was the Royal Faculty of Procurators in Glasgow, which was the original sort of Glasgow Lawyers Association before the Glasgow Bar Association. And they've got fantastic premises in Nelson Mandela Place, and they still do a variety of events. And one of the things they do is continued professional development. So they just asked me, I've been at a couple of their talks, and they just asked me, could you just come and talk about something? And I had it in my head that when I gave up sex cases, I wanted to talk about this issue, and I'd never get around to doing it just because I was too busy. And so the idea struck me that if I told them I was going to do it, then it would motivate me to sit down and put my thoughts into some sort of order. So it was really as simple as that. And the women from Justice for Innocent Men heard about it, and they came they asked me if they could come, and I wasn't quite sure if it was only for lawyers, but as it turned out, it wasn't, and they were able to come. And I was really, really pleased to get to meet them, because I was wondering how long it would take for the public to wake up to this. I mean, the lawyers woke up to it a long time ago, but, we're busy and obsessed with what we're doing that minute. So, understandably, I've done it. You come out of court on Friday and you're absolutely, raging, as we say in Glasgow, about something that's happened on the Friday, and the whole weekend you're still angry, and then you go in on a Monday and you start a new case and you forget all about it because you've got to concentrate on what you're doing, So there's that as well, and a general kind of respect for the job that the judges do. It's a difficult job, and it's not fair. I don't think it's fair to be putting the boot into them publicly when they're not allowed to talk back. But this is different because these are reported cases, and I'm able to, I'm not giving away any trade secrets. You can go and find mention of these cases in the case reports.
Yeah. The other thing that I was discussing yesterday with the campaigners off camera was, how do we fix this? Because is it the law itself, the way it's written? Is it the way the prosecutors will challenge it constantly? There's a witness came on board.
This is Lola.
Have you got two dogs?
Two, aye. Don't know where one's sleeping in the conservatory, I think. She's the friendly one.
What I was saying yesterday was, where is the problem here? Is it the way the law's been written? Is it the way that the prosecution are going to challenge it all the time? Is it the way that judges interpret it? And if we can understand that, then we can maybe then look at how we fix it. So what's your professional opinion on where is the problem and how do we fix it?
Craig, the truth is nobody wants to fix it. It's not getting fixed. It's going to get worse. It's going to get worse. Nobody wants to fix it. So the law is there. So the only people who can repeal the law is the SNP. They've got the numbers in Holyrood to do it. They're introducing stricter laws in relation to the way in which trials are conducted. They're doing away with the not proven verdict for a definite. They talked about doing away with juries in sex cases. The agenda is very much going the other way. To make trials even less fair than they are at the moment, rather than to be doing anything. Now, the judges could interpret the law differently, but again, the trend is very much the other way. That once there's been a 3-judge or a 5-judge appeal decision, all the other judges are legally bound to follow it. They don't have any choice. So it's as good as law that's come from Holyrood, and if they don't follow it, as I said earlier, the prosecution can appeal, and then the appeal court sorts it out before the case even gets to trial. So it's the truth is it's not going to be sorted. It's going to get worse. The trials are going to be less fair. There's a higher chance that innocent people being convicted. That's where it is. I wish I could give the women at gyms some hope. I don't have any hope. I think it's going to get worse, and I'm just glad I'm not in that game any longer.
But surely, though, I know it's unlikely because of the current setup at Holyrood that actually it was just taken away. It was just binned as a law. But surely the Holyrood has the power to do that if it was made up with the right people.
Yes. Yeah.
Right.
Well, the first act was a UK act. I think it was the Conservatives in Parliament at the time. But the 2002 Act is an act of the Scottish Parliament, so they could abolish it. But, I mean, do you think Labour's going to abolish it, Craig? Do you think the Labour Party are going to come out and abolish it? There's no chance of it.
It's a hot potato because it's easy to spin it as you're the guy that wants rapists to get off, and that's not the case. You're the guy that wants people to get a fair trial. You still want people to be, sentenced. But so what you're see, this is something I messaged Marcia about this morning. I said, Marcia, something I never told you.
Ask Marcia how much she gets for the Scottish Government for the campaign.
Zero.
Zero. Ask how much Rape Crisis Scotland get for the Scottish Government. And then you'll have a better idea what the chances are of changing the legislation.
Yeah.
Have a look, Craig. Have a look how much Rape Crisis get for the Scottish Government.
I'll Google that. But that, what I'd said to Marcia, I texted her today, I'd sent her a copy of the video that I put out last night. And I said to her, look, there's something I didn't tell you about me yesterday, it just never came up. And that's the fact that I'm now the leader of a political party in Scotland, the SDP, and I'm hoping to get elected into Holyrood next May. said, so I want to learn more about it, but I kind of think I've learned enough about it that this is, intrinsically wrong. It's not right. And it's something that I think I'll, if successful, take a lead on in there and try and, fix this for the inside. And because of the way our party's constituted, we have the power in the Scottish SDP to create policies that are devolved powers. So, the members that we have the same concerns. If I make this offering to them and they agree with it in the democratic process, then that would put it into our policy, our manifestos.
Well, let's be honest, Craig. It's a democratic process where Maggie Chapman was allowed to vote on whether she should be disqualified for the committee.
Well,
whether she should be disqualified, she was allowed to cast and vote. So what they do is when there's any suggestion on law reform, they set up. It goes to the Justice Committee, and the ruling party, which has been the SNP, they put 3 SNP MPs on the Justice Committee. So whenever they have to take a vote, they still decide what happens in the committee, and it's the committee that decides. Essentially, they report back to the full Parliament. So when they were debating abolishing jury trials, there was 3 SNP members, including John Swinney, he wasn't the leader of the party at that point, but he had been the leader. What are the chances of the two? What are the chances of the two SNP members of the committee voting against John Swinney, who used to be the leader of the party? What the chances are?
Aye, you just do what they want. They get what they want all the time. But
even any law reform committee is loaded with SNP. You can't change anything. So the idea of proportional representation, you get in the Parliament, but if you go into a committee to discuss any law reform, if you're lucky, you get on the committee, but you're outnumbered 3 or 4 to 1. It's really difficult.
I had an interesting.
I'm not saying you shouldn't try. I'm not saying you shouldn't.
Don't. You know me from old as well, Thomas. If I think there's injustice, I'll do as much as I can, and sometimes win, sometimes you don't. But I had an interesting meeting with an ex SNP, Alex Salmond at the time was the First Minister, and he was an ex-cabinet minister for the SNP. This guy. I'm going to do a podcast, so his name will come about then, but it doesn't matter for purposes just now. And we were talking about another thing. It was a podcast I was working on about quite a complex matter, and he agreed to meet me because he knew about it. And when we arrived, he was, "Oh, here you're going to stand for Holyrood, Craig." I went, "Aye." I went, "I think you'll be voting for me, right?" And he just laughed. He went, "I wish you well, because it's folk like you that we need in there, folk that know right for wrong and will challenge things." And he went, and if you do get in, he went, "I'll give you some pointers." And I went, "What do you mean?" And he says, "There's a lot of things that you can do in there that even when I was an MSP, it took me years to figure it out." And one of the things he told me was, in fact, it was the only thing he told me, but he said, "I've got loads of these that will tell you. Any MSP can actually get into any committee room. You don't need to be a member of that committee. And furthermore, you have the right to ask any committee member any question you want, or any witness in a committee meeting." And I was like, "Seriously?" He went, "Aye." I went, "How much fun could I have with that? I'd never be out the building. I'd either be in the main chamber, hitting the point the order button constantly, or in these chambers just going, 'Oh, hold on a minute, Ross, why are you evidently interviewing a pal of yours? I can tell the way you're talking and discussing, and this is meant to be stakeholders,' one of these buzzwords when, we're deciding how we're educating our children. And now, you might not have any effect in the whole scheme of things, bar making sure they're accountable. And all these things are recorded and put out in the public domain, and people can be made aware of the absolute nonsense that's going on up there. So, that's the kind of thing that, I'm keen to get involved in, and I don't want to be that guy that turns up at Holyrood 3-4 times a month. Doesn't bother having, what do you call them, surgeries with your constituents, and just hoping that you get 2 terms for a pension. I don't even want to do 2 terms. I think 5 years up there and without going into detail, you'll know what I'm talking about. I've got a good handle on this kind of insipid waters that are involved in politics, and I've got no desire to spend the rest of my days being involved in that. I want to go in there for 5 years, and what I want to do after that is hopefully inspire other people to say, "Do you know what? If that big guy can do that, I can do it." And the next time we have an election, we have more people that are normal and in it for the right the right convictions. So kind of that's where I am, and I digressed a wee bit. But it's interesting that you say that's kind of the only way we can fix this is parliamentary involvement.
Yeah.
Yeah. So I think that kind of makes me more determined to get involved in this campaign, and it'll just give the detractors something else to throw at me, I suppose. But I kind of see this as an injustice, and if one person's convicted wrongly for any crime, then that's unfortunate. But the fact that even everybody that gets held trial for these things, having the ability not to give it a fair trial and a fair, hearing. I take it all these are jury cases, Thomas.
Yes.
Aye.
Well, I mean, it applies in non-jury cases, but it would really need to be a very, very minor sexual offence for it not to be a jury case. I can't really think of that where it would need to be, but it really applies in non-jury cases. But I can't imagine a sex case which would go non-jury, really, other than for public exposure or something.
Yeah, there was something else somebody mentioned to me yesterday.
What they might have mentioned, it was just occurring to me that this comes at a time when essentially they've done away with the requirement for two sources of evidence. So, if a victim speaks to somebody and claims that she seemed to be distressed and she claims that she was raped, then that's enough now for the case to go to court. It's quite technical, but so the result will be that more cases will go to juries, because some cases would never even be taken up in the first place. Other cases would be taken up, but then at the end of the Crown evidence, the judge would decide, well, you don't have two sources of evidence, so we're stopping the case right now and it's not going to the jury. There's going to be less of all of that, which means there's going to be many, many more cases going to juries. And they're doing away with the not proven verdict. That's a definite. Yeah. So, we're going to be the only country in the world with two verdicts where you can get convicted in an 8-7 majority. The only country in the world, Craig, the only country in the world where you can get convicted 8-7. And people have been convicted 8-7 of murder, And if 15 people in a jury and 7 of them think you're innocent, if that's not a reasonable doubt, I don't know what is. But in Scotland, you can get convicted 8-7.
That's exactly the point I was about to raise, and I'm not sure which of the guests that came on camera was talking about it, and it might even have been off camera.
Marsha.
And she was saying that, and I was like, "What are you talking about?" And she said it's the worst ratio in Europe, right? And
I was wrong. She's wrong. It's actually the world.
Aye, it's worse than she maybe said to me. World. And I think the case that she was keen to talk about, I think that was, and she said that there was jurors in tears because they were like, "I can't believe this man's getting convicted."
Yeah. I mean, they don't. You don't tell us the majority. You don't. I mean, sometimes it creeps out, but it's not announced in court. So a lot of people have been convicted 8-7. They don't know it.
Because and I was talking to somebody. I was talking to somebody after the event, a friend. And he went, surely that's not the case. I went, well, you get a majority decision against you, you go to jail, you're guilty. And it could be 8-7, it could be 8-7 in every case. We just don't know. Listen, it could be 14-1, right? But, you get convicted in 8-7 and off you pop. And that's a severe doubt. So how's that? So what's the sort of standard across the rest of the world then? If it's no just a majority, is it like?
Well, in England, best examples, England has really been copied in Australia, Canada, America, Ireland. Well, at one point, obviously, it was the English system they were operating with. So in England, when the jury go out, the judge says we need a unanimous verdict, 12 in favour of conviction. But after about 2 hours, they can bring them back in and say, right, we'll now accept 10-2, So in England, they need to convince 10 of the jury before there can be a conviction. Same in Ireland, I think, and in most common law countries, Canada, Australia, America, So, and the reason, when I never thought this was right, and any time I raised it, people said, but we've got 3 verdicts. You know, we've got the not proven verdict, and everybody else only has
Mm-hmm.
two verdicts. I
Mm-hmm.
never really saw how that balanced it up, you know, because in most cases,
Mm-hmm.
the not guilty verdict really is a non-issue. You know, in most cases, by the time you get to the jury, there's some evidence. If there wasn't some evidence against you, then you
Mm-hmm.
wouldn't be at that stage. So most cases are either guilty or not proven, you know, by the time you get to that stage. So although on paper there are three verdicts, really in practical terms, in most trials there's really only two realistic verdicts. So the idea that three verdicts balances up the idea that we're the only country in the world where you can get convicted 8-7 never made any sense to me at all.
I didn't know that. I genuinely didn't know that. But it was, I mean, you mentioned something there. I'm going to ask you just one question on it. I would love to do a whole podcast on it alone, and that is the non-proven, which a lot of my viewers are not in Scotland. They'll be like, "What is that?" So, can you just, and again, you even explain to me, because I kind of don't really understand what it is, and I'd love to do a whole podcast about the history of it and the pitfalls about the taken away. But what does it mean in layman's terms? A not proven guilty. A not proven judgment.
Yeah, I mean, I think the easiest way to explain it is I've always thought there only should be two verdicts. There should be proven and not proven for the jury, because essentially in every single case, the question for the jury is, has the Crown proved the charge beyond reasonable doubt? So it's a binary question. There's only two answers to that, yes or no.
Yeah.
You know,
Yeah.
and so I always thought that the sensible way to proceed is you say to the jury, the verdict's open to you, are proven or not proven. And if they found the charge proven, that would be recorded as guilty. And if they found the charge not proven, they would record it as not guilty. And that would mean that the jury had nothing to do with guilt or innocence. Because actually, if you get a not proven or even a not guilty, it doesn't necessarily mean that the jury think you were innocent. It just means they don't think the Crown has proved the case beyond a reasonable doubt. But most people think if they believe you, if you go in and say, listen, I was in Blackpool at the time when this happened in Glasgow, I had nothing to do with it. Nothing whatsoever to do with it. Or you say, I look a bit like the guy who stays in the corner. It was him that done it. He told me it was him. You know, so if you've got a concrete line of defence and the jury believe it, that would always be a not guilty, you know. Or even if you're just saying, I would never do anything like that, I'm an honest person. Whereas if they think, I'm not sure about this, there might be something in it, but definitely there isn't enough to justify sending a guy to jail for life or 10 years or something. That is the kind of situation where you would expect there to be a not proven. And as I say, given that no case goes to the court if there isn't any evidence, and it doesn't get to the jury unless there's enough evidence, there's not many cases of the first type. Mostly the jury are saying, well, we know what the evidence is. The question is it good enough to go to conviction?
That's a very interesting way of looking at it, that you would drop the not guilty, not the non-proven. And it kind of makes sense when you listen to the language behind it. So no, that's interesting. And I don't want to get dragged up. This whole concept just really interests me. So I could probably do an hour on that alone. I don't, that's, you know, that's obviously is for another point. So Thomas, thanks for your time. It's been intriguing as usual talking to you. Is there anything that we've not covered that you want to add to this argument on these current legislations?
Well, there is, I mentioned earlier, there is a Supreme Court decision. We haven't yet given a judgment on it, so it's possible that the Supreme Court might say the Scottish judges have been getting it wrong all along and that they have to roll back a bit and be a bit more generous in allowing cross-examination and different things. But as I said, I know some of the people who were involved in the case and they weren't really that optimistic, I've got to say. You know.
So, so you spoke about this before. I didn't consider.
Yeah. There's two. There's two.
So is this a Scottish case that's been presented?
Two Scottish cases.
Is it Scottish case? Is it a Scottish case? Right. Sorry, I didn't even consider that. I just thought you were talking about maybe an English case there. So, that's interesting.
No.
There's two.
So the case. Remember, I told you about the case where the couple started off in the pub and ended up back at the house.
Yeah, I didn't realise that was a Scottish case.
Aye, that's a Scottish case, and the other one is a So basically, the other one's Daly, and in Daly, it must have been a kind of family situation, and the victim claimed that the accused had raped her when she was 13, and she'd been pregnant. He'd made her pregnant, and she had given birth, and that was investigated and proved to be complete nonsense, and they weren't allowed to raise it. So she'd actually gone to the length of lying about the fact that she'd been pregnant and given birth to a baby, and the jury never got to hear anything about it. So that went to the Supreme Court as well.
Incredible. Right. And has that one been heard at the Supreme Court? Or decision made?
I misquoted it. That was like the other. The lawyer in that case had taken the view, I'm never going to be allowed to ask this, and hadn't asked it. And he appealed on the basis that his lawyer was hopeless, basically. But the appeal was then refused on the basis, well, even if he had applied, it wouldn't have been allowed anyway. So the lawyer was right. So you never lost out any, because even if he had put the application in, it would have been bounced. So what are you complaining about?
Yeah.
So the two of them were really in the same kind of situation, and both they went all the way to the appeal court in Scotland. Appeals were refused in Scotland, and they get permission to go to the Supreme Court in London. And they've all been argued, and just waiting for the judgments in relation to that. I don't really know what the delay is. Often people ask me if it's out yet, and last time I checked, it wasn't. I'm sure I would have heard if it was, because everybody's dying for it to come out to see what the Supreme Court judges think of the issues we've been discussing.
So if the Supreme Court find in favour of the defendant, that could in turn have a positive effect to any future cases in Scotland. Well, that's interesting. Well, it'd be good to hear what's happened with that. Listen, Tom, the last time you came on, we spoke about it was just before the hate crime became an act to a bill, or about an act. We've obviously got some new developments on that, but maybe now's not the time to be talking about hate crime with me, particularly.
I think I said nobody would ever be charged
again going forward.
Yeah, I think I said.
No, you said successfully.
Aye. All right, well, I still stand by that.
So you need to get advice off Tommy Ross. I think the comment was successfully. And I think what we were talking about back then was we were saying that, it's like the Offensive Behaviour at Football Act. There's probably nobody will get convicted and successfully charged, just been convicted. They couldn't have in the law, any particular law, the day before the hate crime became an act. So that's maybe revisiting when it's safer to do so. Plenty of my viewers will understand why I'm saying that. Just so, listen, Tom, thanks very much. It's been great. I'm sure the viewers will enjoy this. The one that we did previously was well watched and well received. So, just thank you very much, and I'll just say to you bye to my guest now. But thanks very much for your time. It's been much appreciated. I'll be resetting before I finish the recording. Okay. So, guys, right. Oh, doing that. Switch you there. You don't need to disappear, Tom. I'll sort it here. Where am I? There I'm there. Right. So that was interesting. That was a fantastic conversation. I'm sure lots of people have never heard about the things that we were discussing before now. So that's, a good thing to get it out there in the domain. And if you enjoyed the video, you want others to know about this, click a share, click a like, put some comments below. If you've not already done so, please consider subscribing to the channel. And if you hit the notifications bell, they'll tell you, keep informed about any future podcasts we're putting them out. The most important thing of all, unless you're the type of person that says you want democracy, you want fairness, but you don't want people to have fair trials, then not you. But everyone else, have a great day. Cheerio, bye now.